What is going on, you guys? Welcome to the little gaming channel. Today we are going to pick up a load in Texas and take it down to Texarkana, Texas. All right, let's get into it. Also, we're going to be watching the plea deal with YSL member Quamarvious Nichols. All right, he pleaded out this week. So let's start watching the video and get into this delivery.
Now let's have him at the podium because he's going to have to take an active part in this entry. All right.
Okay, sure.
Sergeant, can you swear him in, please?
Raise your right hand. Swear firm testimony you give the truth, the whole truth, and nothing but the truth.
Yes.
All right. State, spell your first last name for the course. Allow me to the mic, please, sir.
Quamarvious Nichols. Quamarvious. Last name Nichols. Nichols.
All right.
Get that? Okay. Do you want to do it again? All right. Slow down. Your name. Spell it for this young lady right here.
Okay, my name is Quamarvious Nichols. First name Quamarvious. My last name Nichols. Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvious Nichols on indictment 22 SC 183572?
Yes.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
Yes.
How old are you?
29.
And how far did you go in school?
I got my GED.
I did not hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carried a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that that's what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this matter with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand that as a part of the negotiated agreement, the state will null, prosper, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Well, there's only one charge that a guilty plea is being entered into, so
Under my breath to that.
there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Partisan Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183-572, how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
That can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to...
Hang on just a second. You also have, so 4 years for that, to file a direct appeal. You have 30 days from the date of sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right.
Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as the list of the state would expect to show that what has already come into evidence that on July 3rd, 2017, as well as October 23rd, 2018, that is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserve, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steele Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle when that vehicle was searched, Your Honor, and this was in October 2018. They found marijuana as well as sandwich baggies that would be used to package drugs, and there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Woody Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This is on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas and carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as Wyman Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at the early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMillan and Darius Ford. It also did include a retaliatory shooting of a white fan associate, and then ultimately it led to a murder of Chanel Drinks, who we believe is a white fan associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Chanel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got to his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there's a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect of, you need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving as well as the car that Mr. Nichols is driving both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both with this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, the Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We can know through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out, on March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, we'll call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended after arrest warrants were ultimately taken out for the murder of Mr. Drinks, Your Honor. Given where we are in the case, Your Honor, we know that Mr. Nichols, we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made a decision to move forward with this recommendation for the RICO count, Your Honor, for count one.
Mr. Harvey, are y'all acknowledging a factual basis to the count one, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So that, but yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, you have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL. And that concludes our factual basis.
And again, once again, we again categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case, and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
May I approach with the waiver of rights for me?
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, each individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
Man, I done went the wrong way. That about a bitch.
And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does
I
not
always do that.
ultimately go through with this guilty plea, and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thorough.
I am infamous for turning down the wrong damn street. Why'd I even turn there when the arrow's supposed to be going straight?
All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than
Lord
the
have
statement
mercy.
with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days, and he will be 30. And at 30 years of age, he has a wife, he has got a 13-year-old daughter, he's got a 10-year-old daughter, and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta, and you know, we're at this point before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning, and he has sought the support of friends in this courtroom and others in this courtroom.
Let me go straight. Bruce Harvey is getting choked up over there.
He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence.
He's been with him forever, for 2.5 years.
And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I ask the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right. I find there to be a factual basis for the guilty plea to the RICO count 1 of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy, and that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count 1 of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count 1 is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe Mr. Harvey is correct, can be a productive member of society, and this is an opportunity for you to do that and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
So walk us through what you think of this plea deal you were able to negotiate.
Well, insofar as it resolves all of these charges against Mr. Nichols, I think it is an exceptional result. It's an exceptional result for the following reasons. No murder charges, no gang charges, no factual acknowledgments required by the state, no other charges except for one conspiracy charge that was factually underpinned by convictions that Mr. Nichols already had from almost 6 years ago. So that result, I think, is an excellent result for him and resolves all of these cases. You know, the RICO charge in this case was a RICO conspiracy. And underlying the RICO conspiracy were all the 100+ factual predicates, some of which have already been resolved by and against Mr. Nichols. Some of them we hadn't even gotten to. And I don't believe the state would have been able to prove Mr. Nichols' responsibility for those predicate acts. So this was, yeah, we were in a conspiracy. Yeah, we acknowledge that factually the underpinnings of the RICO conspiracy are satisfied by what already was presented and what he had already pled to, but nothing else. No, as we said, no murder, no guns, nothing else. No gang charges. Listen, there is no gang charge. He did not acknowledge being in a gang, being responsible for being in a gang, committing any kind of violent act on behalf of any gang. Yes, I was in a overall conspiracy. Thank you, see you later.
You were behind kind of the original mistrial motion that led to this flurry of negotiations.
Yes.
Just walk us through kind of how it went from that to taking a plea.
Well, you know, the state made several errors in the case into which we had to ask for a mistrial. So
Attorney
we were
Westmoreland.
satisfied that
That's who that
the
is,
judge,
Attorney
she
Westmoreland.
heard us and our motion and asking for a mistrial, and that errors cannot be repeatedly occur in front of the jury and inadmissible evidence being heard by the jury. And so we're glad that the judge, heard our motion and said, do you want a mistrial, and will you take a mistrial without prejudice? And and then we went into negotiation, and we're pleased with the outcome of our negotiation.
How relieved are you after, being part of Georgia's longest trial that, your portion of this at least is over?
Well, now we can wear B suits and A suits. No. How relieved are we? Once you're in that routine and once you're there with your fellow lawyers and your fellow co-defendants, I mean, it's almost ritualistic. I mean, we were there every day. We were working every day. So, we're relieved because the result for Mr. Nichols was the right result. Now we have to deal with the rest of the world. They can release us from our kidnapped status.
You gonna miss courtroom one scene?
Yes and no. Yes, clearly. But I'm glad that all of us could work that resolution. And that resolution, again, for Mr. Nichols was no gang, no factual acknowledgments, no murders. So it is, he can go on about his life and get out. He's a young man. He's a nice looking man. He's a smart guy. So I'm hoping that this projects him forward and doesn't leave him in the lurch.
So you're almost at this part.
I saw that you choked up during.
I did.
And this had to be a difficult decision because during this time, he's become family in a sense.
Yeah, very much so.
How difficult was it actually deciding not to go with the mistrial without prejudice versus go ahead and make?
Yeah, but that allows him to do it again. That allows the case to continue and doesn't resolve the case and doesn't give any sense of finality. Without the factual acknowledgments, without agreeing to the state's factual contentions, this ends the case. I mean, it's over. A mistrial without prejudice means it's subject to recurring. And there's a whole other group of severed defendants that are still out there and awaiting resolution. And I think we're in the best posture at this particular point with this particular judge in the 2 years that we've been litigating this and everything that has happened to strike at this particular point.
Yeah.
You were talking about, you guys do a word of the day. Or
yes.
Can you talk about that and kind of what's next for him once he gets out?
Well, can I tell you that he is a very receptive young man. He's like a sponge. He doesn't have a formal education. He doesn't have a consolidated family upbringing. But he's very curious and he's very smart. So we would use a word or get a word a day and we would define it. We would use it in a sentence. And you can see his intellectual curiosity. He's a really good kid and a smart kid. And I want him, truly.
It's true. I mean, we've spent 2 years,
yeah, Bruce
over
Harvey
2 years.
keeps getting choked up when he's
with our
talking
client.
about him. He's been with him over 2 years.
And like Attorney Harvey was saying, he's intelligent, and he's so much more than, unfortunately, what comes out during a trial process. And, the word a day, he asked the word a day. Myself, Attorney Harvey, we go back and forth of picking a word, and we teach him the pronunciation of the word, and then 2-3 weeks later he'll use a word that he learned 2-3 weeks before, and he keeps it going. And so he's a great individual, and we're glad that this is over for him. It's been 2 years too long.
Yeah,
He's
shout out
also
to his
developed a
wife.
pretty sophisticated understanding of the system. I mean, he can look at me when something happens and go, hey, this is what happened. This is what should happen. I know what is going on here. So he, like I'm saying, he's a sponge. I mean, let's
all involved in YouTube and media and also in the prosecution. What are you hoping to come from all of the things that you've shared and done with?
Well, let me just shout out to the YouTube folks. I mean, we all watched it. We all watched the commentary, and we love the commentary, and we point out the commentary.
Shout out to the lead attorney.
So we've had a good time seeing the reaction to what has happened in the courtroom. And, people have an idea of what happens in court, that it's always, inflammatory, it's flamboyant, it's this, and something always interesting has happened, except for the days and days we have with phone records. And so somebody up there saying, well, this is the phone number that's associated with, Miss Johnson. And really, what was the name of that? What's the address? And let's write that down. I mean, it's just drudgery. It is, section after section after section. And I know it's all part of a puzzle, but I hope that everybody understands that it is not all excitement, and that you've seen how deeply everybody has dug into this case and all of the things that have been litigated week after week and day after day after day. So we appreciate what everybody says.
Any message to the rest of the defense attorneys still fighting for their clients in this case?
Good luck.
Do you think this plea is going to affect any of the rest of the case moving forward?
Well, something, I think we were lucky. Not lucky. Let me try to find a better word. We were able to resolve our case in a different fashion than what I understand has been put on the table for others. When I say we resolved it to a single count, we resolved it without those other acts, we resolved it without any factual acknowledgments. If you have been following this closely, every other person in this case who has pled has signed a plea agreement with factual acknowledgments. YSL, I'm a member, it's a gang, I did this, I would do this on behalf of the gang, and I did this, and I agree that that's what the situation is. We're
going to go over this after he finishes.
Able to resolve our case without any of that.
When Bruce Harvey finishes, we're going to go over the counts that they dropped and actually what he pled to.
And that's the distinction. And I certainly hope, I wish the very best for every one of those young men, and including, Jeffrey Williams, who's been sitting in jail for years now. And he is an incredible talent and a wonderful young man. So I wish the best for all.
Last question from me. Do you know the 7 years? I know there's like a complicated formula of how early in theory he could get out.
Well, it's not that complicated.
Okay.
It doesn't take Einstein. Remember, E equals MC squared. Do we know that? We do know that. Do I know? No, I don't. If I knew, are you going to ask how much time?
I was going to say, how much time does he have left of the 7 years?
But he's got, what, 24 plus 5, 29 months in. There are parole guidelines for his offense, but at the end of the day, it's up to the Georgia Board of Pardons and Paroles. And if I knew that, I would be the richest lawyer in the world, and I would be on a beach with a cocktail in one of those little umbrellas, and my pinky would be up. Okay.
I think it was kind of a cliffhanger if he had any other outstanding issues that would affect any of his probation going forward. To your knowledge, well, I know that you can't go in depth, but is there anything that will affect his?
Well, I don't know the answer to that. There is nothing related to this case. There is nothing that he has in his past that is affecting his ability to move forward and appropriately serve this case, this sentence. Okay, his kids and his wife look forward to getting him back home.
Okay, here we go. So what he pled, what they dropped, what the overall charges was, count one was the racketeering, right? Count one was the racketeering. Let's get out of here on the straightaway. The racketeering was the count one. Count 49. The racketeering charge carried 5 to 20 years. That was the count one. Count 49 was the murder charge that carried life. Count 50 and 51, participating in criminal street gang activity, carried a sentence of 5 to 20 years. Count 53 and 65, possession of a firearm by a felon, both carried a sentence of 15 years to run consecutive to count one, which was the racketeering charge. Count 54, possession of a firearm during the commission of a felony, which carried a sentence of 5 years, and that was to run consecutive also to count one, which was the racketeering charge. They dropped all of those charges except number one, which was the racketeering. And his part in the racketeering, his participation into in furtherance of the organization was selling drugs. That's what he pled to. All the other charges were dropped. You know, so they read all those charges. Hilton read all that stuff, which was just a bunch of pomp and circumstance, right? Which was just a bunch of show. She read all that stuff just to say he pled to the one charge, which was the racketeering. You know, and honestly, that's all they all wanted. That's all the DA wanted. That was the feather in her cap, which was the racketeering. Racketeering was her thing. That's all she wanted. Racketeering, racketeering, racketeering. So she got it. So Quamarvious, I guess that's his name, Quamarvious Nichols, he pled to the one count of racketeering, and his participation in the enterprise was selling drugs. Was that drugs they said they found. Other than that, that's all they had on him. So he's going to do time, and from what I understand is that he has about 8 to 9 months to go, depending on the parole board. But he's going to get credit for the time served for the 2.5 years I think he already spent in prison. So he's going to get credit for time served, And the 9 months, the 8 or 9 months would have been the time that he had to serve in order to be eligible for parole. So that's that, man. So he's eligible for parole in 8 to 9 months. Whether he gets out in 8 to 9 months, that is up to the parole board, as you heard Hilton say, and you heard his attorney say. So it's totally up to the parole board whether or not he gets out in 8 to 9 months. If he keeps his nose clean, if he goes straight and narrow, does everything he's supposed to do, I don't see any reason why they wouldn't let him out. But we also see that, you know, he has to do a bunch of years on parole, probation, or whatever it is. He has to do a bunch of years, like 13 years or so. He has to keep his nose clean, man. You know, he can't hang around the same people. You know, we already heard Jeffrey Williams. He got off. He walked away. He walked away with time served. And he's leaving Atlanta. Best thing for him to do is leave Atlanta. Because you know, Fannie Willis and the rest of them evil people, they are going to be after him. So get out of Atlanta, brother. Leave that place. Get out of there. Leave Atlanta. I'd be on the next thing smoking, man. Whatever they need me to do, I'd be out of that piece.
Keep left and then turn left.
Be out.
Turn left.
But looks like we don't have that much longer to drop this load off. Get across this highway here. Make sure nothing hits me. Let's crank up this engine sound some. Oh. You guys can hear the roar of this engine. There we go. Hope you guys can hear that engine well. Hear my horn? The other guys that's still in there, Yak and the rest of them, man, shit, who knows what they're going to get, man. Yak and the rest of them, ugh. That's going to be something else, man, what the rest of them get.
Go straight on.
They got 2 more, man. Got 2 more people. And I think they had to wait till this morning. Today's the 1st. They had to wait till this morning because the district attorney tried to withdraw the offers. So the judge told her to leave it on the books until today. I don't know if they accepted it, but we will find out. So the attorneys left is, who we have left as the attorney? I know we got Max still there. And, what is that other guy's name? It'll come to me in a minute. We are almost at our destination, you guys. we are almost there. Not long to go. Probably about another 5 minutes and I'll be there. Definitely cotton. I see them cotton bales right there. Them big rolls. That's definitely cotton. Yes, sure. Whoa, whoa, hold on, baby. Let's see here. Back this thing up. Let's go. Yeah, there we go. Got it in there. All right. That's it, man. Let's unhook this baby. Collect our money. And we are good to go. You guys, thank you for coming out and watching the video. I am Aaron with the Little Gaming Channel. I appreciate you guys. Please hit the like button and subscribe on your way out. Holla at your boy.